Okay, thank you everybody for joining. I think we're going to get started. My name is Nancy Neerman. I am the Assistant Director of the Education Debt Consumer Assistance Program. I am joined here by my colleague Elisa Picard. I will be doing the presentation. Elisa will be behind the scenes answering questions. All questions should be typed into the Q&A. The chat is disabled. You can read information in the chat, but you're not going to be able to actually enter information into the chat. So please put all your questions in the Q&A. We will answer questions as we go through the webinar. If you have any questions on anything that we're discussing, or any other questions about student loans, you can put them in the Q&A. We'll break periodically to share some of those questions and answers. And if we don't get to all of them, we will follow up after the workshop is completed. Everybody will get a copy of the recording and the deck once the web workshop is completed. And I also want to add that we were just joined also by Carolina Rodriguez, who is the director of EDCAP. She will also be behind the scenes answering questions. So with that, I think I am going to share my screen and we will get started. Okay. And if somebody can just confirm, Carolina or Elisa, that you can see the screen.
Yep, looks great.
Okay. So we have quite a packed agenda here today. We're going to go through all of these topics, so I'm not going to just rehash them here. We're going to start with a little bit about our program, the Education Debt Consumer Assistance Program, or EDCAP. We are a program initiative of the Community Service Society, or CSS. CSS is a large nonprofit. It's been around literally since the 1800s. The EDCAP program was created in 2019 specifically to tackle the issue of student debt. We are quite a unique program, the first in the nation really on a statewide level to offer free services, information, and consultation to borrowers in New York State who are struggling with student loan debt. And the program was created basically for two different reasons. Number one, because student loan debt is the second largest consumer debt in the nation, only behind mortgages. It's a $1.7 trillion issue nationally, and it's almost $100 billion here in New York State. And in addition to the fact that it's just a very large problem, the system, as you all well know, has been very, very difficult to navigate, and has undergone a lot of changes, and it will be undergoing a lot of changes going forward, which of course is why we are holding this webinar today. But the services that we offer are broad. We will help you do everything from working out your best repayment options, helping you gain access to forgiveness and cancellation and discharge programs, helping you file applications, resolving issues with lenders and servicers. Will act as your advocate. We can prevent you from going into default or help you get out of default so that you can avoid involuntary collections. And then more recently, we've branched out to do a lot more pre-college counseling, where we will actually help a borrower fill out the FAFSA form and counsel you a little bit on how to fund higher education going forward. So really, we're kind of a soup to nuts through the life of a student borrower. We can help you wherever you are in this stage. So let's get right to some important updates. And of course, the most important being that the OBBBA, or the One Big Beautiful Bill Act, which is essentially the new tax and spending cut bill, has been signed into law. It was signed into law on July 4th. And that's going to bring some major changes to the student loan landscape, including changes to borrowing limits, new repayment options, some changes to income-driven repayment forgiveness, elimination of short-term relief programs. And we're going to go into all of this stuff in detail a little bit later. Now, one thing that you should know is that the budget bill, as I'm going to refer to it going forward, the budget bill does not alter public service loan forgiveness in any meaningful way in that bill. The only thing that was mentioned in the public service loan forgiveness in that bill was that the new income-based repayment plan, which is called RAP, is going to be eligible for PSLF. There is another process that's happening right now at the Department of Education. It's called negotiated rulemaking, which is exploring changing the definition of what a qualified employer is. And that's based on the president's executive order that he issued earlier this year. And it really has to do with identifying whether or not some employers might be engaging in what the administration deems to be illegal purposes. That's an ongoing conversation, but nothing has changed about PSLF right now. If you were eligible for PSLF last month, you're still eligible for PSLF, and if these new rules do go into effect, it wouldn't happen until the mid-year next year. Okay, so we want to, of course, talk about the SAVE plan and what is ultimately going to be the end of the SAVE plan. So this plan is already facing legal challenges, as you probably know. These lawsuits were filed last year. An appeals court placed an injunction on the Department of Education last July, ordering them to stop enrolling new borrowers in SAVE or calculating payments under that plan. And that led to the Department of Education placing everybody that was in the SAVE plan at the time into a forbearance, which is where, if you have not gotten yourself out of that forbearance, that's where you would still be at this point. So what did this ultimately, what does this ultimately mean? It means that borrowers that are currently enrolled in the SAVE plan remain in that forbearance. That forbearance was extended until October 31st, 2025. The time spent in the forbearance does not count to forgiveness. Now, up until now, this has been a non-interest bearing forbearance, meaning that interest rates were set to zero, so no interest was accruing on your account. That's going to change starting August 1st, so just a couple of days from now. Interest will start accruing on those loans as of August 1st of 2025. That doesn't mean that you have to make a payment. You can remain in the SAVE forbearance until it ends. Like I said, it's scheduled to end right now at the end of October. It could be extended again if there is no final decision from the courts on that date. If not, if there is a decision, then it's likely that the forbearance would end. But in any event, you can remain in the plan. And it's estimated that some 7.7 million borrowers are still in the plan. You can remain in that plan until the forbearance actually ends. So regardless of what happens with the legal challenges, this plan is going to be eliminated in the new budget bill. It's just a question of whether or not it will be available for the next few years, or whether it's just going to end with the legal challenges. Our assumption has always been that it's not going to survive the legal challenges, so it's probably not a plan that you're ever going to be able to enroll in going forward. Now, what do you want to do if you're on the SAVE plan? That's a big question. We have a lot of clients that ask that question on a regular basis. The SAVE plan is going to go away one way or another. It's either going to go away through the courts, or eventually be eliminated through the budget bill. You can stay in the SAVE forbearance for now. If you're not ready to make payments, you don't have to. Again, interest will be accruing, and you can always, just make the interest payments if you want to do that, or you can just not pay and have the interest accrue in your account. For a number of people, and we have lots of clients like this, particularly those that are looking to get out of the SAVE forbearance so that they can earn credit towards public service loan forgiveness or even income-driven repayment forgiveness, you can switch plans. For a while, the IDR applications were not being processed at all. That has opened up again. They are processing applications. There is a big backlog, and it could be months before you actually get your application processed, but you can submit the application right now. So you can, as existing borrowers, there are a number of plans that you can enroll in if you're eligible. So you can enroll in income-based repayment, pay as you earn, or the income contingent repayment plan, ICR. You can explore these options by running the IDR application. So you do that by going to studentaid.gov, at /IDR. And then you want to click on the recertify or change your income-driven repayment plan option, and then select switch my current plan, follow the instructions, run the calculator. And if there is data matching to your tax returns in the IRS database, you're going to see what your options are. You can also use the Federal Student Aid Loan Simulator on the FSA website, if for some reason you can't get a match by just running the application. If you do it through the application, you don't want to submit that application unless you're ready to change the plan. Once the save forbearance ends, if you don't choose a plan, there's a strong possibility that you're going to be placed in a standard fixed plan, which for a lot of people is going to be a very high payment and probably unaffordable. Just remember, even if you don't choose a plan at the time the save forbearance ends, you can still enroll in a plan once the save forbearance ends. So it's better to do it and be positioned before the end of the forbearance, but if you want to wait until the forbearance ends, you can do that as well. You just don't want to wait too long, because at some point they're going to be sending you bills to make payments in that standard plan. Okay. So before we go on, I'm gonna just stop quickly and see, Carolina, is there anything that we want to discuss right now before I move on? Carolina? Okay. How about Elisa?
I think Carolina may be mid answering a question from a borrower.
Okay.
And I think we've pretty much handled in the Q&A the stuff that needs to be handled there. So we're good for now.
Okay, great. So I'm sure the next few sections are going to elicit a lot of questions. Okay, so starting with borrowing limits, and these limits are going into effect on July 1st of 2026. So let's go through them all. Direct subsidized and unsubsidized loans for undergraduate school, there's no change to the borrowing limits. So remember, as it currently stands, a student can borrow, there's annual limits that range from $5,500 to $7,500, depending on what year you're enrolling in, and an aggregate limit for dependent students of $31,000 to complete their undergraduate degree. That doesn't change. Direct unsubsidized loans for graduate school, however, this is where the changes start to go into effect. For a master's degree, you're going to have a $20,500 annual limit. That's actually the same as the current limit, but you'll have a lifetime limit of $100,000 to borrow for the master's degree. This is in addition to your undergraduate degree loans, and it's in addition to whatever your parents may take out for you for Parent Plus loans. For professional degrees, things like legal degrees, medical degrees, you're going to have a $50,000 annual limit and a lifetime cap of $200,000. For graduate plus loans, and remember, the plus loan program, whether it's for graduates or for parents, allowed borrowers to borrow up to the cost of attendance. So the gap between the cost of attendance and any other aid that you might have gotten, including all these other loans. It allows you to borrow up to the cost of attendance so that you can fund your entire, for a grad student, you can fund your entire graduate school experience or all of your education, and stay within the federal system and avail yourself of all those protections. So starting July 1st of 2026, the Grad Plus loans will be phased out. That means that you're going to be stuck really with the limits that we just discussed for the direct unsubsidized loans for graduate school. And in a number of circumstances, people are just not going to be able to complete their graduate degrees within those limits. So you may have to turn to other options like private student loans or looking for more scholarships, fellowships, that kind of thing. Now, there is a one important exemption to this rule. So they're going to grandfather borrowers. If you've got a graduate plus loan dispersed before July 1st of 2026, you can continue borrowing graduate plus loans for up to 3 years to complete your current program of study. So if you're if you're just starting now, you're just starting to take out loans, and you've got at least one loan dispersed before July 1st, 2026, you'll be able to continue to borrow plus loans within the system for up to 3 years just to finish the program. Parent plus loans, they're not eliminating them, but they're going to be imposing some important limits. So there is an annual borrowing limit of $20,000. That's for all your kids. And then there's a lifetime borrowing limit of $65,000 per child. And that's between the two parents. So it's not, you can't say if one parent takes out $65,000 worth of loans for a kid, the other parent can't take out additional loans for that same kid. It's between the two parents. The lifetime limit is $65,000. Again, there's a grandfathering clause here. If you received a Parent Plus loan before July 1st of 2026, you can continue borrowing under the current rules, which means up to the cost of attendance for undergraduate school for your dependent children, for up to 3 additional years, so that until your child completes their program of study. Now, one big caveat that is really more impactful for Parent Plus loans that is for graduate school loans, even though you're grandfathered into the borrowing limits, when it gets time to paying those new loans back, you will have to pay them back under the new rules. This is particularly important for Parent Plus borrowers, as you'll see going forward, because the new rules essentially state that Parent Plus borrowers will not have access to any income-driven repayment plans and therefore may not be able to pursue forgiveness programs. So we'll talk more about that in detail. With the Graduate Plus loans, it's a little bit easier of a decision because even though you'll have to pay under the new rules, you will have access to the new income-driven repayment plan and forgiveness programs going forward. So a little bit of guidance here for concerning the borrowing limits. If you're no longer borrowing, so if you're done borrowing your loans, none of this really impacts you. What you really want to focus on is selecting the best repayment plan, and we're going to talk more in detail about those repayment plans. Right now, it would be IBR, PAYE, and ICR. And if you're pursuing public service loan forgiveness, you just want to make sure that whatever strategy you're applying right now is giving you credit towards PSLF. Now, if you are currently in school and still borrowing, if you received a Graduate Plus or Parent Plus loan before July 1st, 2026, you can continue to borrow under the current rules for up to 3 more years, as we just discussed. You want to review your borrowing plans with your financial aid office to understand your eligibility, and particularly when it comes to Parent Plus loans, you're going to need to be strategic about how you do this borrowing, because you will have to pay those loans back under the new rules. If you're planning to start school after July 1st of 2026, the borrowing options will be more limited. All the limits that we just discussed will be firmly in place. So things like Graduate Plus loans will not be available. You'll be capped on what you can borrow with Parent Plus. So you need to plan ahead to figure out how you're going to cover the costs, particularly Parent Plus borrowers who may choose to do something other than stay within the federal student loan system. And then explore alternative funding options such as scholarships and state aid wherever possible. So we're going to go into a lot more detail about the Parent Plus situation as we go through this presentation. So let's talk for a minute now about the repayment plans. So the repayment plan options for future borrowers, so this will be for loans that were taken out on or after July 1st of 2026. People who have those kinds of loans are only going to have 2 different options. One will be the standard fixed repayment plan. So it's similar to the current standard fixed repayment plans, but the payback period is going to range anywhere from 10 to 25 years based on the size of your debt. The other is going to be the new plan that's based on income, which is called the Repayment Assistance Plan or the RAP plan. So this is the only plan that's based on income that is going to that is going to be available to you if you have any loans that were dispersed on or after July 1st of 2026. And how this plan works, it calculates payments at 1 to 10% of your adjusted gross income. So that depends on your income, whether it's going to be 1 or 10, but the maximum is 10%. If you're earning $100,000 or more, it's going to be a straight 10% of your adjusted gross income. Adjusted gross income, by the way, for anybody that's interested, you can find that number on your tax returns on the 1040 form for the last 2 years. That's been on line 11 of your IRS 1040 form if you want to figure out and see what your AGI was. This payment is going to be reduced by $50 for each dependent that you claim on your tax return. The minimum payment is $10 under the current IDR plans. And when I say, by the way, when I say IDR or income-driven repayment plans, that's the umbrella term for the current existing plans, and that would include SAVE, income-based repayment, pay as you earn, and ICE and income contingent repayment. So that's the IDR is the umbrella term. Under the current IDR plans, if your income is low enough, your minimum payment would be zero. Going forward, even if you have no income or if you're only on Social Security or it's a very, very low income, you're still going to be required to pay $10 per month. Spousal income, if you're married, can be excluded if you're filing your taxes separately. So this is good. It's going to give you more options to lower your payments if you are married. Now, generally, if you're married and you file your taxes jointly, payments in these plans that are based on income are calculated on your combined income. But again, if you're filing your taxes separately and you're married, the payment will only be based on your income alone. There's no protected income and no adjustment for inflation in this new WRAP plan, where there is both of these features in the current plans, which makes them a little bit more attractive in a number of instances. But one of the very positive things about the WRAP plan is similar to the SAVE plan, unpaid interest is not going to accrue. So that just means that if your payment does not cover the cost of the interest every month, and if you have a large loan balance and a moderate income, very often it does not, that unpaid interest will not be added to your account balance, so you will never see your balance increase. May not decrease if you're not paying enough to hit the principal, but it will not increase and balloon as it's done in the past. This plan offers forgiveness. It's called income-driven repayment forgiveness. So basically, by virtue of being in this plan, if you make 30 years of qualifying payments, you will have you'll be eligible to have the balances if there are any discharged after that period of time. The current repayment plans offer this kind of forgiveness in between 20 or 25 years. So they've extended the amount of time that you have to pay to get your balances forgiven. And then payments in the WRAP plan will be eligible for PSLF, which is a 10-year path to forgiveness. Okay, so let's just go through, we've broken this down to how this is going to work for borrowers with existing loans, borrowers with future loans, and borrowers with basically a combination. So we'll start with existing student borrowers. And the definition of this is that if you have all your loans dispersed prior to July 1st of 2026, and you're not planning on taking out any additional debt. So you're going to be right now able to access payee, ICR, and income-based repayment or IBR under the current rules until July 1st of 2028. A modified version of the IBR plan should become effective. Well, it was technically effective as of the date that the bill was signed. It may take the Department of Education a little time to fix their systems and notify the servicers to make the adjustments on the modified version of IBR. But essentially, the modified version of the IBR plan eliminates the income test. There was on the old versions of these plans and on payee, if your income exceeded, if your there was a calculation that looked at your income compared to your loan balance, and if the calculation exceeded the amount that you would pay in a standard 10-year fixed repayment plan, you would not be eligible for those plans. They've eliminated that right now, so there's no income test, which means basically if you've got direct loans or FFEL loans, you can enroll in an IBR plan. But the payments in those plans will continue to be capped at no more than the cost of the standard 10-year fixed repayment plan. So this is generally a plus for borrowers. For borrowers, there are two different versions of the IBR plan. If you had any loans that were dispersed before July 1st of 2014, the payment is calculated at 15% of discretionary income, and balances are forgiven after 25 years. If your first loans were dispersed, on or after July 1st of 2014 up to July 1st of 2026, the payments will be calculated at 10% of discretionary income, and balances will be forgiven after 20 years of qualifying payments. These borrowers, if you fall into this category, you're also going to be able to choose the wrap plan whenever that becomes available, which should be no later than July 1st of next year, or the new version of the standard plans. Those will all be available to you. But payee and ICR are going to be phased out on July 1st of 2028. So if you're still enrolled in those plans as of July 1st of 2028, you would be transitioned to the IBR plan, but you would also have the choice of moving into the wrap plan if that were more attractive to you. Now let's talk about new student borrowers. So these are people whose first loans were dispersed on or after July 1st of 2026. You're only going to have access to the standard fixed repayment plan or the repayment assistance plan, which I just described. And that's the wrap plan being the one that's based on income. Okay, now we're going to talk a little bit about the repayment plans for parent borrowers. So we're going to start with existing parent borrowers. Again, all loans dispersed prior to July 1st of 2026. Parent Plus borrowers have until July 1st of 2026 to consolidate their loans, and then after that, you'll have to enroll in an income-driven repayment plan if you want to retain access to any of the income-driven repayment plans and therefore retain a path to forgiveness. So if you're done with your Parent Plus borrowing, but your loans are not consolidated, you need to make sure that you're going to consolidate them before this date. And the consolidation has to be completed before July 1st of 2026 to make sure that you continue to have access to plans based on your income, particularly if you're pursuing a forgiveness program. Once you consolidate and you enroll in an IDR plan, which could be right now ICR, you should also have access to the modified IBR plan when they make the modifications. By July 1st of 2028, if you're still in the ICR plan, you would be automatically switched to the IBR plan. Parent Plus borrowers, whether they're consolidated or not, are not going to ever have access to the new wrap plan. For new Parent Plus borrowers, so where first loans are dispersed on or after July 1st of 2026, your loans are only going to be able to be repaid in the standard repayment plan, even if they're consolidated. So that essentially means that Parent Plus borrowers in the future will have no access to the wrap plan and basically no path to income-driven repayment or public service loan forgiveness. This is an unfortunate rule that was built into this bill. It's unfair, but that is the rule, and it's important that everybody understands the rules. Now, another really important part of these rules, and people should understand, is that the rules state that that you must pay all your loans back in the same repayment plan. So what this means for existing Parent Plus borrowers, if you are an existing Parent Plus borrower and you take out a loan on or after July 1st of 2026, you can only pay the entire balance back in the standard plan. So this is going to be really important, and you're going to have to be strategic about how you think about how you think about funding the rest of your child's education if you're in the middle of this process. And we're going to talk a little bit more about that further into the presentation. So this slide is just an illustration, and this is just one particular scenario on how the new RAP plan is going to compare to the new income-based repayment plans. The assumptions are all over here on the right. So there's a loan balance of 85,500, an interest rate of 6.58%. The 10-year standard repayment plan, which acts as the cap, based on these numbers, is actually $974, which is why you see in the IBR plans, the payments are never going to be more than $974, regardless of what your income is. And again, the IBR plan is only going to be available to borrowers who only have loans dispersed prior to July 1st of 2026. If you have any loans dispersed on or after July 1st of 2026, they all have to be paid back in RAP or the standard plan. But it's a pretty straightforward calculation. Again, this example includes one dependent, so meaning they'll get a $50 deduction to the base calculation, and then a family size of 2 when it comes to the IBR plans. In general, and I played around a little bit with these calculations, the lower and more moderate your income is, the more attractive the RAP plan is. It's generally more attractive than the IBR plan based on 15% of your discretionary income until you hit the cap. Once you hit the cap in those plans, the RAP plan can become, in some instances, significantly more expensive depending on what your income is. But generally speaking, particularly if you're single and you have no kids, the RAP plan is going to compare favorably up till about maybe $90,000, $100,000, and then it starts to become a little bit more expensive. In this particular model, or with this particular example, the benefits of the RAP plan tend to wane a little bit after the $75,000 mark. This is just a table. We created a couple of timetables, which just kind of it reinforces what I just said. So I'm not going to go over this in detail. This will be here for your reference. But I just want to say again, because I know this is a point that's confusing a lot of people, because of this rule that if that you must pay all your loans back in the same repayment plan. If you have existing loans but take out new loans on or after July 2026, you must pay all your loans back in the same repayment plan. That goes for student loan borrowers and parent borrowers. Now, the one exception is if you have a combination of the two. If you have both student loans for yourself and Parent Plus loans, you can pay the student loans back in the RAP plan because they're eligible, but you will have to pay the Parent Plus loans in the standard plan. So that's the one place where they allow you to use two different plans because the Parent Plus loans are not eligible for the RAP plan. And then again, this is the options for repayment plans for future borrowers, loans dispersed on or after July 1st of 2026. Really is the options for anybody that's got loans dispersed on or after July 1st of 2026. Other changes that we're going to be looking at in the bill, for loans dispersed on or after July 1st of 2027, those loans will no longer be able to access economic hardship or unemployment deferments. But I would also stress that particularly with in these two circumstances, you may find an affordable version of the income-driven repayment plans if you can't access these options. And you're only going to be allowed to take 9 months of forbearance within any 24-month period. The current rules on deferments and forbearances are more generous than this, but for these loans dispersed on or after that date, you're going to be adhering to a new set of rules. But for people with defaulted loans, there is a process that allows you to get yourself out of default called rehabilitation. Effective July 1st, 2027 for any loan, you will have 2 chances at rehabilitating a defaulted loan. Currently, you only have 1, so this is actually a bit of a benefit. And then finally, for the borrower defense to repayment and closed school discharge programs, these are 2 programs. Borrower defense to repayment discharges debt if you can prove that your school is guilty of some kind of misconduct or malfeasance. They will discharge your loans. Closed school discharge allows you to discharge your loans if your school closes while you're enrolled or shortly after you leave the school. There were a set of new rules, the 2022 rules or Biden era rules, that would have made the discharges in these programs easier. As a result of this bill, they've been delayed until July 1st, 2035, which usually means that the Department of Education is expecting some other event to perhaps dispense with this rule. And that event may well be the fact that these rules are currently being challenged in the courts. I believe they're with the Supreme Court at this point. And the courts may may deem those rules illegal. It doesn't mean that there aren't other existing bar defense to repayment and closed school discharge rules. There are. There you would revert to the rules that are currently in place, but they're just more difficult to get a favorable discharge in those older rules. Okay, I'm going to stop there. I would imagine there's probably been a whole bunch of questions. So I'll start with Carolina, and if you're writing, maybe we'll
No,
go to.
sorry. Sorry about that. The issue is that I had my computer connected to my monitor and it didn't pick up the sound, but I
Ah,
figured.
okay.
So, I mean, we're in a roll. We have answered 44 questions. There's a lot of questions, obviously, about what to do regarding plan changes. And there have been a lot of questions on the timing of the different plans. If you don't mind, Nancy, if you could go back to that timeline, sheet, you're gonna get this and you can really digest it a little bit better because it's a lot for me to explain. But the takeaway right now for a lot of people, based on the questions we've been getting, is probably more if you're on the safe forbearance and what do you do now? What plan do you choose? And I want to spend a second talking about that. So if you're on the safe forbearance and you want to actively get credit towards public service loan forgiveness, at this time you really want to evaluate whether you should switch to another plan. What can you switch into? Technically, you can choose between IBR, ICR, and payee. Those plans should be available for current existing borrowers, those borrowers that do not take out more loans after next year, until 2028. So you could continue earning credit under those plans, right? So you should be fine. However, if you're having to choose between IBR and payee and your payment amount is the same under either IBR and payee, we recommend you choose IBR because that will be the only plan that will continue to live on after July 1st, 2028 for current borrowers, right? So that's why you're going to hear us say if you have to choose between IDR plans because you're leaving safe, we recommend IBR unless payee one you're eligible for it because not everyone is eligible for it. Depends on when you took out the loans. Payee in some cases for some borrowers may be cheaper than IBR, so that's the only time that you're hesitating between IBR and payee. If you want to avoid obviously multiple transitions, IBR is your safest bet right now. Now, if you decide to switch plans, they're going to ask you whether you want to leave your forbearance because you're on the safe forbearance. And if you want to get credit, switch plans now, you want to say that you want to opt out of the forbearance, right? So be sure that when you're doing the application, you say that. Otherwise, you submit the plan request, and they're gonna keep you on the safe forbearance probably until they eliminate it altogether. And that could be we don't have a good sense of what that will be. It could be in October or it could be like next year. We really don't know when that's gonna end. So again, you're gonna get this. Slide 16 has what you're currently eligible in 2025, what things look like in 2026, and what things may look like in 2028. If you're a Parent Plus loan borrower, it gets really tricky. So you reach out for a one-on-one. Anyone can reach out, but I highly encourage people who have Parent Plus loans to reach out to us now because there might be some action that you need to take, and we want to get that going if you need to do that. I'll stop there. I don't know if Elisa has any other points to elevate based on the questions she has been answering.
No, I think yours were the highest priority that I saw as well, Carolina. I would also just underline the point that Nancy made at the front end here regarding public service loan forgiveness, because we've seen a bunch of questions about it. Nothing about it has changed so far. There is currently a negotiated rulemaking process taking place to attempt to implement the guidance that came in the form of a presidential executive order having to do with changing which kind of organizations qualify for PSLF, but that change has not yet occurred, and it will not be retroactive. It will be prospective when it is made. And everything else about PSLF certification remains the same. You need direct loans, and you need to certify your qualifying employment, which we would recommend that you do at least once a year while you are in the process of making payments toward the 120 qualifying payments.
Okay. There's just one question in the queue that I'm going to answer live because I think it's a really good question and I'm not sure that we know the answer to, but we should put this on our agenda of things to answer. So somebody is saying that they're set to graduate in the summer of 2026 and that they have Grad Plus loans, but they have a second degree planned for the fall of 2026. And the question is, will they be able to get Graduate Plus loans under these new rules for that second degree? The answer to that question is I'm not sure that you would be. I believe that the rule states that you would be able to continue taking out Graduate Plus loans to complete your current degree that you're working on. But that is a really good question, and it's something that I think we're going to do a little bit of research on and come back to. My gut response, and I welcome Carolina or Elisa's view on this, is that maybe not.
So I agree with you that you would probably not be eligible to borrow up to the cost of attendance. There is still the question of whether you would be able to borrow up to that limit, the new cap. And as Nancy said, food for thought. We need to get back to you. Feel free to reach out to us and I'll put my email there. I will also say related to that, because someone, Nancy, asked me, they're in one of the extended graduated repayment plans, what we call a standard plan, whether that was going to continue to exist and not be impacted by all these changes. I said that maybe, and I say maybe, there will always be a standard plan, which I think has been mentioned or will be mentioned in more detail, but we don't know what's going to happen to the current versions of the standard plans, or unless, feel free,
Well,
Nancy, Elisa, to chime
no,
in.
my understanding is that if you're an existing borrower, again, you don't take any additional loans out after July 1st of 2026, and you're in one of those plans, like a graduated plan or extended plan, that you will be allowed to remain in that plan. The question that I had is what happens if you switch out of it at some point and you want to get back into it? I suspect that if you ever switch out of it, and you wanted to get back into it, it would not be available to you. But my understanding is if you're in the plan now and you just remain in the plan, that you should be able to continue in that plan. Okay.
Great.
Shall we
Thank you.
move on? Okay, just want to go over some strategies for tackling debt. These are, this is something that we've said pretty much for years. We've been using this chart to talk to people about what their long-term strategy is for tackling their debt, in addition to just addressing the immediate issues. And frankly, even with the all these changes to the budget bill, the strategies are going to remain largely the same. How you get there may be different, but the basic strategies are the same. So the first strategy is pay your debt in full as quickly as possible. This is going to be for people who have larger incomes in comparison to their loan balances, and they have the ability to make more than the required payment or make lump sum payments. The idea here, if your goal is to pay it off in its entirety, you want to pay it off as quickly as possible because you're going to save on interest. So the faster you pay it off, the less money you'll pay overall for the life of the loan. The middle bucket, which is where most of our clients live, and probably a lot of you, is pay the minimum required and pursue some forgiveness program. So you want to find a forgiveness program like public service loan forgiveness or even IDR forgiveness. And you want to make the minimum required payments until you meet the eligibility requirements to have the entire debt discharged. And then finally, pay the minimum required until death do you part. This is really for older borrowers that maybe have taken out late in life student loans for themselves or a lot of Parent Plus debt for their kids. The goal here is, in some instances, these people are, at or in retirement, so they don't necessarily have the ability to do like a PSLF type of forgiveness program, and they realize that they may have to pay for 20, 25 years. And if you're 60 or 70, that could be the rest of your life. And the reason that we put this on here is that because people may not realize that, unlike most other consumer debt, um, federal student loan debt is discharged in debt, meaning that it does not accrue to the borrower's accounts. It's also the forgiven balances are not taxable. That was just a portion that was just actually specified in the new bill. So basically, once you die, this no longer becomes you don't have to worry about it becoming a burden to anybody in your family or your loved ones. So you just find the cheapest repayment plan and you make that payment, and just rest easy that it's not going to be an issue for anybody else in your family. And then the repayment options, they're going to be more limited, but basically it's going to still fall into two buckets. The traditional repayment plans, which are in the future going to consist of just one standard fixed repayment plan with a payback period from 10 to 25 years, or an income-driven repayment plan, IDR plan. Currently, there are 3 options, 4 if you include SAVE, but nobody can actually get into the SAVE plan. In the future, there will just be one. The benefits are, I think, kind of obvious. In many cases, the income-based plans are going to be more cheaper than the traditional plans, particularly if you have a high loan balance and a moderate income. The IDR plans do offer loan forgiveness anywhere between 20 and 30 years. They are, in some instances, required for other forgiveness programs like PSLF. And of course, these are going to be best suited for people who have high balances and moderate incomes. Going forward, or actually the downside of the IDR plans in comparison to the traditional plans is the annual recertification of income, which they're trying to make that a little bit easier going forward. And then potential interest accumulation, which will not happen in the WRAP plan, but would continue to happen maybe in IBR, PAYE, and ICR. That's basically, this is always going to be a critical consideration for anybody when determining what their student loan strategy is, well, I've got my strategy. How do I get there? What plan do I enroll in? We do want to say a word about income-driven, the income-driven repayment account, or the IDR account adjustment. This was a one-time account revision that was done during the Biden era, that was going to offer qualifying payment credit towards income-driven repayment forgiveness. So this is the plan that offers forgiveness after 20 or 30 years of making a qualifying payment, and it has no employment requirement. So the account adjustment, what it did was it gave credit towards IDR forgiveness based on a set of more relaxed rules. And that wound up basically last year. At the beginning of this year, there was a tracker that was briefly on your federal student aid accounts that showed you how much credit you have towards IDR forgiveness, but they've taken the tracker down. Supposedly they're going to put it up again, but we don't know when that might be. The important thing to know here is that the information actually is still on your account, and we have figured out a way to get to it. And the way that you do that is you log into your federal student aid account at studentaid.gov. You open up a separate tab in the same browser. And then when you get this deck, you'll have the link. You put the link into the browser, and it's going to produce this ugly looking HTML file here on the right. And when you see it, it's going to have this little box at the top that says pretty print. You want to check that off. it's going to give you a more readable version. This is the more readable version, by the way. Without the pretty print check, it's virtually unreadable. But you want to save that file or copy and paste it to a Word file and save it to your records. Even if you don't understand how to read it, you can reach out to somebody like EDCAP or other folks that understand the data, how to interpret the data. And it's going to tell you how much credit you have towards the IDR forgiveness in these different repayment plans. And any credit that you accumulated in any one of the existing plans, Save, Payee, ICR, is going to be transferable to the IBR plan or the WRAP plan when that becomes available. So you won't lose the credit. Okay, public service loan forgiveness. I know we were talking a little bit about this. Just generally to recap the rules, you need to make a 120 qualifying monthly payments. So that's 10 years of qualifying payments, after which remaining loan balances are forgiven. Now, a qualifying payment is defined as an on-time payment made in full on or after October 1st, 2007. That's when the program started. So anything before 2007 October doesn't count. You must have direct loans. You must be in one of the income-driven repayment plans or paying on the standard 10-year fixed repayment plan. And then there are employment requirements. So you must be working an average of 30 hours per week for one or more qualifying employers, which are generally nonprofits and governments concurrently at the same time. The payments do not have to be consecutive. And at the time that you meet the employment requirements, you submit your application for forgiveness, and you should, by the way, be employed at the time you submit that last application. The forgiven balances are not taxable at the federal level, nor are they taxable in New York State. There was nothing in the budget bill that changes the taxability on PSLF. So those are the rules as they stand now. You may have heard of something called the PSLF buyback. The buyback is a relatively new program that allows you to purchase PSLF credit for months that you may have spent in a disqualifying status, like, for instance, the Save Forbearance. So for all those months, like a year now, that people have been sitting in the Save Forbearance, you in theory would be able to purchase those months back. In order to do this, though, you must have 120 qualifying months of employment on record. That's not 120 qualifying payments. It's just qualifying months of employment. So if you don't have that on record, but you've reached that milestone, you want to submit your PSLF certification form to make sure you get the employment verified. It may not increase your qualifying payment count, but the employment, you'll have the 120 months of employment on record. And then the months that you choose to buy back, or the months that you're allowed to buy back, must bring you to 120 qualifying months of payments. So not everybody is eligible to do this right now. You can't purchase months prior to a consolidation or months that you spent in a school deferment, grace period, or in default. One of the big questions right now is the payments are, in theory, according to the rules of the buyback, supposed to be based on the payments that you were making in an income-driven repayment plan prior to entering into these periods of disqualifying status, or after, or IDR plans that you were, payments that you were making in IDR plans afterwards. The big question mark when it pertains to the Save Forbearance is the government and the Department of Education is not allowed to calculate payments based on the Save Forbearance. So we're not exactly sure if they give you a buyback offer, what they're going to be basing the payments on, but you would see that when you get the actual offer. If you're ready to do it, you can submit a request through the PSLF reconsideration portal. You'll have a link to that here. And then you simply select the PSLF buyback option, and that's it. It's a very simple process. You don't have to do anything more than that, and then you just wait to get an offer letter. Now, big caveat here, the buyback applications, apparently it's a manual process in terms of processing these applications, and they don't seem to have a lot of resources dedicated to dealing with this program. So the progress that they're making in processing the applications is very slow. We have some information that's being released as a result of a court case that shows that in June, they only processed 22 applications, and the backlog is now up to 65,000, and it's probably going to continue to grow. And that implies that it could take about 2.5 years to clear the backlog. So that's not to say that you shouldn't do the buyback if you're eligible for it. We encourage you, if you're eligible for it, to do it. I would be cautious about relying on that solely to get you to 120 qualifying payments. You might want to pursue other strategies at the same time and see whichever one gets you there first. And then, as Elisa mentioned a little bit earlier, you can continue to submit your PSLF certification forms to verify your employment. You want to do this using the PSLF help tool from the studentaid.gov website, and you want to select an electronic signature from your employer. You want to request an electronic signature from your employer. Any applications that are submitted with manual signatures are just taking a very, very long time to process, whereas the ones with electronic signatures can be really quick. So if at all possible, you want to do it that way. And you can reach out to us for help with that if you're not quite sure what to do. So some overall guidance to kind of sum up a lot of the things that we talked about. We're going to go by starting by what is your repayment strategy. If your goal is to repay your loans in full, you should consider one of the traditional plans. Right now, you can consider the standard extended graduated plans. If you're not taking out any loans beyond July 1st of 2026, you should be able to enroll in those plans. And you can always pay more than the required amount. As I was saying before, the faster you pay it, the less you'll pay overall. If you're pursuing IDR forgiveness, so this is the 20 to 30-year forgiveness that doesn't have an employment requirement, there are currently 3 IDR plans that are available to those who are eligible, and that's IBR, Payee, and ICR. Payee and ICR were going to be phased out by July 1st of 2028, but you can enroll in them now and stay in them, again, if you don't take out new loans after July 1st of 2026. You always want to look at IBR first, as Carolina was explaining before, because that is the plan that's going to survive beyond July 1st of 2028. But if Payee or ICR are are cheaper for you right now, you certainly can enroll in them, particularly if you're pursuing PSLF, and maybe you've only got another couple of years to go before you'll get to 120 qualifying payments. You should choose the cheapest option available to you. And just remember, this is just a reiteration of what I said before. There are 2 different versions of the IBR plan, depending on when your loans were dispersed. And as a reminder, qualifying payment credit for IDR forgiveness earned in SAVE, Payee, and ICR will be transferred to the IBR plan or to the RAP plan. If you're pursuing public service loan forgiveness, again, I think I kind of just reiterated all this, but if you're enrolled in IBR, Payee, or ICR, you should just continue making those payments to earn credit. If you're currently in the SAVE forbearance and haven't done it yet, we probably would recommend that you submit an application to switch. And just remember, when you submit an application for an IDR plan, you're going to be placed in a processing forbearance, even if you're currently in the SAVE forbearance. And periods of up to 2 months spent in processing forbearances are eligible for PSLF. So you could get a couple of months of free months of credit towards PSLF without having to make a payment. And then submit the buyback application if you're eligible, as we discussed before. In terms of selecting the RAP plan when that becomes available, there's a number of things that you need to be aware of if you have the options. The RAP plan can, in some instances, be cheaper than the existing repayment plans. Existing student borrowers can switch to the RAP plan. If you do switch to the RAP plan, and even though you may not have loans taken out after July 1st of 2026, it's not 100% clear whether or not you can switch back into IBR at that point. If you switch to IBR, you should be able to switch into the RAP plan at any time, but I'm not sure you can go back. That's kind of a question that we've yet to answer. Payments in the RAP plan are going to count towards both PSLF and IDR forgiveness. And like we said, the IDRF credit accumulated in SAVE, IBR, and pay as you earn should transfer to RAP. But remember, the WRAP plan has a 30-year path to forgiveness versus 20 or 25 years in the other repayment plans. So the payment may be cheaper, but you'll be paying anywhere from 5 to 10 years longer. So that has to be a consideration if you're pursuing IDR forgiveness before you make that switch. Maybe not be as much of a consideration if you're pursuing PSLF, because PSLF is going to have a 10-year path to forgiveness regardless of what plan you're in. And then for Parent Plus borrowers, again, we want to reiterate, this is really important because there is a window that you have to act if you're not consolidated. Under the terms of the new bill, the existing Parent Plus borrowers must consolidate their loans really before July 1st of 2026, and that means the consolidation needs to be completed. So it generally takes 2 to 3 months, could be a little bit longer, to process a consolidation application. You want to make sure you allow for that time and don't submit the application on June 15th and expect it to be completed by July 1st. So you're going to be consolidated and then enroll in an IDR plan. You would have a little bit longer to enroll in the IDR plans. Borrowers are going to have access to ICR, and Parent Plus borrowers who consolidate should have access to that modified version of IBR when it becomes available, which could be very soon. If your Parent Plus, if you have any loans that are dispersed on or after July 1st of 2026, you'll have no access to the WRAP plan, no access to IBR plans, and thus no path to IDR or PSLF forgiveness. So if you haven't done so already, you want to think about consolidating any existing loans and enrolling in IDR plans. If you plan to take additional loans for the fall 2025 or spring 2026 seasons, you want to consolidate those loans immediately upon disbursement, so that you make sure you get that you're consolidated by the July 1st deadline. If you have defaulted Parent Plus loans, now's the time to take care of that. You can consolidate to get those loans out of default. So you want to pay attention to that. And we talked about, again, if you plan to take any additional Parent Plus loans out on or after July 1st of 2026, you're going to have to pay all your debt back in the standard plan. And that means you're going to need to be strategic about how you decide to fund your child's education beyond that point. There may be situations where you want to just think about a private loan after July 1st of 2026 because you don't want to jeopardize the path to forgiveness for any Parent Plus loans that you've already got up to that point. Or if you can explore more options for scholarships, if you have family resources, that's always a good option as well. Okay, I'm going to stop there and see if there's any questions before we finish this out.
Yeah, so I think you already touched on something that I just wanted to confirm because a question came up about what if I need to take out more Parent Plus loans and I already have Parent Plus loans, and you need to take out after 2026 just to confirm more loans, then all the loans you have would be subject to the standard plan, right? Like you wouldn't be able to get IBR or WRAP.
Correct.
So I don't know if you already mentioned this, that like the only thing that we can think of or that I can think of is that if you have two-parent households and you already have the bulk of the Parent Plus loans, or it may not be the bulk, but if you want to at least preserve the option for an income-driven repayment plan, for the current Parent Plus loans, have the other parent take out any future loans.
So I'm going to say a word about that, Carolina, because there's a question mark, and we hope to answer this. I don't know whether if since the new rules state that you cannot take more than $65,000 out for the same kid, and that's total between the two parents. If the one parent has already reached the $65,000 for that child, I'm not sure that the other parent could take
They would
additional.
be grandfather in. If the student is already a student, right?
I don't know. I'm not 100% sure. I think we
I
have
think
to.
that the grandfather in would be.
Yeah.
Because it's a separate question. I think they would be grandfather. But this is all this to say, this is how complicated it is that you're gonna have to really think about it. there's a couple of areas or things that you could do. You could reach out to us. It's easier for us to really understand your situation and explore and follow up with you. As Nancy mentioned, this is all coming out and this is where we're at this point. The other place is hopefully financial aid offices are going to be savvy enough to, and on top of this, to give you a little bit more guidance as well. But definitely reach out if in doubt, and we can work through it. Other questions that were coming up, PSLF, a lot of PSLF questions. Uh, just know that the best way for you to track your progress towards PSLF is by submitting your employment certification form using the PSLF help tool and requesting an electronic signature from your employer. Regardless of where you're at, just remember that if it's an income-driven repayment plan, whether it's IBR, ICR, eventually wrap, as long as it's an income-driven repayment plan, they are eligible for PSLF. You just have to meet the other requirements, the employment requirements. I will put it in the chat of how you reach out to us, but basically if you go to edcapny.org, there's a contact us and you can book your own appointment, but I'll also put it in the chat. Elisa, I'll turn it over to you to see if you had any other insights or questions that you want to elevate. I know it's already 1:07.
Yeah, I just want to encourage folks to go ahead and use the contact information that Caroline is going to post to make one-on-one appointments if needed. We have tried to keep up with the questions in the chat. We have answered 89 of them, but we have 40 still open, and I can see that some of them are ones that either Caroline or I have not yet answered because they seem like they may require a little bit more engagement with your student loan records in order to be able to answer the question fully and correctly. So please do go ahead and use the information that Caroline is going to provide to make an appointment, and we'd be glad to sit down and go through this stuff with you.
And I should just mention that if we don't get to all the questions, for the ones that we can answer in a general way, we'll send that with the follow-up email. We'll send the answers to those questions with the follow-up email. Okay, so let me just quickly go through. We just have a couple more slides to go through. I wanted to say a quick word about total and permanent disability discharge. This is a program that allows you to discharge your loans if you have a mental or physical disability that prevents you from earning a livable wage. The key thing here is that this is a program that used to be run by Nelnet, regardless of where your loans were held. They transitioned this now to the Department of Education. I can't say it's been the smoothest of transitions, but there's a new method of doing this. From your federal student aid account, you would go into loan forgiveness and navigate to the TPD page, and there you can either do it electronically or upload certain documents that are required. Again, you can reach out to us for help if you need, if you're pursuing that program. And then a few words about delinquency and default, because as you probably know, the department announced in April that they were going to be resuming collections in May. Really what resumed in May were notices. They were supposed to start doing collections early June on Social Security, but they actually backed off of that. And so they've delayed the actual collections of Social Security offsets for now, although probably that will start up later this summer. And they also are planning to do wage garnishments, and tax refund intercepts have actually started. So if you were subject to that. In any event, just in terms of what to do if you're delinquent on the brink of default, you want to call your servicer. So these are for people who are not quite yet in default, but maybe getting there or getting close to it. Call your servicer and see if they will apply a retroactive forbearance. Remember, if you're delinquent by 3 months or more, they're going to start reporting the delinquencies to the credit reports. The servicer is not obligated to give you the retroactive forbearance, but they do sometimes. And if they do, that could take care of some of your credit issues, and it will at least bring your account current. But you're still going to have to plan for, you're going to have to make a long-term plan, because forbearance is not a long-term plan to eliminating your student debt. You want to explore your IDR options. If nothing is working for you right now, you can look into longer terms of deferment and forbearance. And at least for now, you'll have access to the forbearance and deferments under the existing rules, which are more generous than the new ones. But ultimately, again, you're going to have to make arrangements and address whether it's your budget or finding other jobs to make sure that you have some plan that you can pay back in. If the loan is in default, so after 270 days of missed payments, that's about 9 months, your loans are at risk of going into default. They may not default immediately, but within a few months, they probably will. Being in default basically makes the debt payable in full immediately, which of course is a non-starter for most people. You are not eligible for any income-driven repayment plans, deferment, forbearance. You can't earn credit for forgiveness, and you would have no access to federal aid. And of course, then you would also be subject to potentially subject to involuntary collections. And there are three main ways that the federal government can basically take your money. And they do this, by the way, without having to take you to court. They can intercept your tax refunds. So this is already happening. Although if you filed your 2024 taxes already and got your refund, they're not going to take that. But if you remain in default going forward, next year they could. Social Security offsets, they can offset up to 15% of your Social Security, but they can't leave you with less than $750 per month, which is obviously almost impossible to live on. That is actually on pause, but we expect that to resume later this month. And they can apply an administrative wage garnishment of up to 15% of your disposable pay. The notices on that we anticipate going out later this summer. Actual collections probably in the fall. The government can also intercept funds that may be owed to you from federal contracts or sale of federal assets like treasury funds. Again, they can do this all without a court order. They just will send you a notice and boom, that's it. There is a hotline that's operated by the Treasury Department, because Treasury is one of the ones that do the offsets. They don't do the administrative wage garnishments, I don't think, unless you're a federal employee, but they will do the tax refund intercepts and the Social Security offsets. You can call this number on this page, and it's an automated system. You just put your name and your Social Security number in, and then they tell you whether or not you're scheduled for an offset. If you are in default, though, there are different ways to get out of default. There's two different ways to get out of this default. There's loan consolidation, where you replace your defaulted loans with a new consolidation loan that's in good standing. Or there's something called loan rehabilitation, where you make 9 timely payments over a 10-month period, after which the loans are removed from default. There's positive and negatives to all of these things, and not everybody is eligible for both. The consolidations in general are faster, and if done online, can be done with no cost. Loan rehabilitation can take up to a year to do and generally costs something. It's a little bit more administratively difficult to get through. The rehabilitations right now, you can only successfully rehabilitate a defaulted loan once. Starting July 1st of 2027, you'll be able to do it twice. One thing to know about loan consolidation is if you have an active wage garnishment, you cannot do a loan consolidation. If you have an active wage garnishment, you can do a rehabilitation, and it will remove that garnishment after 5 months of making payments. If you have a court judgment, which is different than an active wage garnishment, if you have a court judgment on, you cannot do either consolidation or rehabilitation. You want to reach out for legal assistance if that's your situation. And that's it. I know it was a tremendous amount of information, and I thank you all for your patience. And so we'll let me just skip. If you're looking to contact us for a one-on-one, this is our contact information. You'll have all of this when you get the deck. So I'm going to open it up, Carolina and Elisa, to the last of the questions before we sign off.
I think some questions that resonate is people were asking where do they look for their current plan enrollment information. So there's two ways. You can go to studentaid.gov, you go under My Aid and then loan breakdown. Usually you can see the type of repayment plan you're enrolled in. You can also go to your servicer website, and you should be able, under like some type of loan details, be able to see the plan. Now, if you recently switched IDR plans and you got a letter saying that you have been approved, it can can take a few days, weeks for that new plan to kick in. If you're really stressed out, you can always call the servicer, and I know it's not ideal, but you can always call them to make sure everything's lined up, and eventually you'll get your new invoice. It does, again, take a couple months for everything to be processed. I don't know right now if it's taking even a little bit longer, but be aware of that. Elisa, anything else?
No, I was noting the same thing about the sort of where do people look for information coming up as a repeated theme. Overall, just really want to encourage people to be prepared, to continue to exert a lot of patience in navigating these processes. All the data that we have received from FSA suggests that the staff cuts there have had a lot of impact on their ability to process any of this stuff. It will all take a lot longer than we want, but we will all get through this together as well. And please don't hesitate to reach out for one-on-one help if need be.
Okay, well, again, thank you everyone for your patience. I hope you found this informative. And we look forward to hearing from some of you in the future. Have a great day.